And welcome back, everyone. Today we are going to be talking about operations. And Francesco, to kick this one off, I want to go back to our first conversation about the legal technology of a corporation as a vehicle to bring in people, bring in investors, bring in capital, all these things that are going to kind of be pieces of this entity that grows and adds value. And I want to kick off with this question. With this group of people and things, what role does the law play on a kind of ongoing basis?
Yeah, it's a great question. So the corporation and really all these legal entities, LLCs, corporations, limited partnerships, and so forth. Yeah, you know, they they're created by the state to enable the pooling of assets and resources to accomplish a business objective. And uh, So in every company, you have all these stakeholders that are contributing to the enterprise. There are investors that are contributing capital. There are employees that are contributing services. There are directors and officers who are conducting oversight of the company. There are suppliers and vendors that are contributing goods and services. There are, of course, customers and end users that are using the products and paying the company. And then all of that is occurring in the context of, um, just the background law. There, there, there are, like laws and courts that the government has that the company is relying on, and so the law exists. The law kind of like mediates and impacts and shapes all of the relationships that I just described. And so, for example, some simple examples are, with employees, there is a whole body of employment laws, federal and state, that mediate and determine and structure those relationships. And so, legal operations on the employment side, include like a host of compliance matters relating to this statutory and administrative framework, and then there's a contractual component to those relationships as well. And likewise, investors who contribute money into the company, there are securities laws that mediate the relationship between the company and the investors, as well as the contractual basis of the relationship. Corporate governance is mediated by a range of laws. There's kind of common law fiduciary duty that determine the obligations of directors and officers. There are administrative and regulatory dimensions to that. For example, companies that are listed on national securities exchanges, stock exchanges, need to meet certain requirements related to their corporate governance. Um, then there's all of these laws that mediate the relationship between a company and its customers. So there are laws regulating how companies can market themselves, and regulations and standards around that. There's laws, that determine what kind of remedies consumers can pursue against your company and so forth. So, without getting into, I've already gotten into probably too much detail, but the basic idea is that all the stakeholder relationships in a company, there's a legal dimension to every single one of them, and and as a company grows, those relationships also kind of multiply. They become more complex and more involved, and then the risks associated with them, because they're more complex and more involved and more numerous. The risks also become magnified. So it becomes, more important to have, good legal systems in place, to ensure that the agreements, the relationships between the company and its stakeholders is clear, is kind of optimized, and and appropriately mitigates risks to the company.
Yeah, this idea of clarity is something that has kind of been a theme throughout this conversation we've had in all of these different areas. Clarity with the relationships you're building with team members, clarity about the kind of capital and the kind of investors that you're going to be seeking partnerships with, et cetera. And it sounds like that is really paramount too as a company grows and scales and this added complexity, added risk gets kind of put into the mix here.
Yeah, I think so. I mean, and I think it's a big part of what we do. We do as as general counsel and business lawyers is, clarity in these relationships is, is like an accelerant. Because when you have that, everybody knows where they stand. Everybody knows what their contributions are supposed to be, what they're getting in exchange, and that just has the effect um, of of making the relationships more effective, and more efficient. And a lot, and there can be a learning curve around this. So in early stages, not it's not uncommon that we work with founders and teams where there are a lot of amorphous relationships, in terms of, you know who's doing what and who's getting what in exchange for it, and I don't know, and that can, you know to some degree, I feel like that is, uh, perfectly normal when a company is really just evolving, from just emerging. It's like an emergent company, and it's not clear what's happening and where it's going and so forth. But at a certain point, though, there has to be a pivot to, okay, this is a thing, and we need to get clear about, how we're all contributing to it, what we're getting in exchange, and then that practice and that habit of clarity, professionalism, and having clear relationships is becomes really important as things grow.
Really a necessary condition for that growth to have that clarity and to be able to carry that through consistently with each new hire, with each new investor or round, et cetera, as you go through the journey.
Yeah, I mean, definitely. I think that what you find is that in the places where you don't have that, there'll be sore spots. There'll be like red flags. There'll be problem spots. That will suck time, energy, and resources. So we try to kind of like head that off, at the beginning.
And it sounds like too, we talked about this with intellectual property. There's a kind of defensive and an offensive nature to that specific area of law. But even here, this clarity and consistency with these relationships, it's going to allow you to go forward kind of offensively into the market to grow, acquire customers, users, while also protecting the relationships, protecting the things that you've built.
Yeah, that's a really, I like that point a lot. It's very true. It's very true. Like in the nature of these relationships, you're kind of like planning for the upside and also protecting against the downside.
Yeah, totally.
Where you want to have clarity about who gets rewarded when things go the way they should, and how much they get rewarded, and so forth. But also, uh, it's equally important to plan for the relationship not working out. And when you have both things planned for, that's a good indicator.
Definitely, definitely. Well, cool. Well, this is a shorter conversation than some of these others, but I think lays a good foundation for some of the things a founder should be considering. Kind of no matter where they are in the journey, whether they are in this emerging company state, or have a more mature, robust operation, to ensure that they're having this clarity and consistency to optimize all the stakeholder relationships that are there.
Yeah, yeah, exactly. I mean, the real purpose of this call is to, kind of, get in founders' minds that at a certain point in the progression of the company, it becomes important to have like really good legal processes. That means like legal forms in place, legal like tracking tools for tracking the legal functions, and processes like systems and processes. For example, for onboarding people and updating cap tables and so forth. So that's a big part of what kind of an in-house counsel will do. And before an in-house counsel comes on board, it's what we tend to do for our earlier stage companies.
Absolutely. Well, cool. Thanks for this conversation, Francesco. As ever, these are on the web for you to peruse, in addition to these other topics and more webinars from some of the experts that speak to some of these different stakeholder relationships.
Thank you so much, Chris.
Thanks.